5 common misconceptions about wills in British Columbia, Canada. You've probably heard someone say, "I am married, so why do I need a will?" Or, "I can just use one of those will kits bought from the store." But here is the truth. These common assumptions can leave your family vulnerable and your wishes ignored. So today, let's clear up some of those misconceptions about wills in British Columbia. Misconception number 1. My spouse will automatically inherit everything that I own, even if I don't have a will. It is easy to assume that your spouse will automatically get everything when you pass away. But in British Columbia, Canada, that is not how it works. If you die without a will, it's called dying intestate. That means your assets will be divided according to the provincial law, Wills, Estates and Succession Act, or WESA, not according to your wishes. If you have a spouse and children, the law divides your estates between them. That includes children from previous relationships, if any. And when it comes to the matrimonial home, the surviving spouse does not automatically inherit it. The spouse only has a preferential right to purchase the home from the estate. So, if you want to ensure that your spouse receives what you intend, a will is essential. Misconception number 2. If something happens to both of us, our closest relative will become the guardian of our child automatically. This is one of the most heartbreaking oversights. In British Columbia, if both parents pass away and there is no will, only a court can appoint a legal guardian for the minor child, even if there are close family members available. Until the court makes that decision, your child may be placed under the care of the public guardian and trustee. You can avoid the uncertainty by naming a guardian in your will. It's one of the most important things that you can do to protect your children's future. Misconception number 3. Once I sign my will, I never need to update it. But life changes, and your will should reflect that. You should review your will anytime one of the following happens. You either get married or separated or divorced. A beneficiary named passes away. You acquire significant new assets, such as real estate. You start a new business or wind down a business. Your children become adults. The executor chosen by you can no longer act. Keeping your will up to date means your estate plan still matches your life goals and your intentions. Misconception number 4. My spouse will be managing my estate when I die, becoming my executor even without a will. Unfortunately, this is not guaranteed. Without a will, your estate will be managed by a court-appointed administrator. Your spouse may need to apply to be appointed and could face delays, costs, or even disputes with other relatives. A properly drafted will allows you to name your executor, someone you trust, who can manage your estate promptly and according to your wishes. Misconception number 5. I can just write my own will using a kit from the store. While it's tempting to try a do-it-yourself will kit, especially when it seems quicker or cheaper, it can come at a cost later, both financially and emotionally, for your loved ones. And here is why. Legally speaking, there is no such thing as a Canadian legal will. Each province in Canada has its own laws, so a will that meets legal requirements in Saskatchewan, for example, will not necessarily be valid here in British Columbia. A notary can help you understand the law, consider your unique circumstances, and avoid unintended consequences. Think of it like this. Would you diagnose yourself with a serious medical condition based on a blog post? Then why would you treat your life's work with less care? Your will is more than just a legal document. It's a way to protect your loved ones, honor your intentions, and preserve your legacy. Without a will, your wishes may never be heard, and your family may face avoidable stress and even conflict. If you are in British Columbia, Canada, and need help drafting or updating your will, I'd be honored to assist you. My name is Nik Eskin. I'm a Notary Public in Vancouver, British Columbia, and I have been helping individuals and families plan with confidence since 2012. Please subscribe to this channel for more guidance on wills, estate planning, and personal legal documents in British Columbia. Let's make sure that your voice is heard, even when you are no longer here. Thank you for watching.